Yes, Mr. Doctor. Any instruction?
But what I feel, my lord, it's maybe Sunbed there. Let them make an inquiry and see.
No, any instruction on your
I
part?
mean, that way I don't have. But then after going through the MP order, that was my lord realization.
Can you have instruction, or we are otherwise thinking if they do not come on notice, we may ask for personal appearance, because without in their absence, we cannot decide this.
So in that case, my lord, can I pray let it be fixed on Monday? I'll try to get the instruction.
You have the instruction. See, it's a Silchar municipal board. They should not, their stance should be clear before this court. It's an
Lordship will find this person, chairman,
Hmm.
he at that time, he was a senior advocate, my lord.
Uh,
And if they have such a poor idea of
You
writing,
see, in that, what happened on last occasion, I have seen a State Bank of India. Without them, we cannot decide, because action is that bank on one bank account was frozen. There is a dispute between two brothers. Now, under what we cannot. So we'll have to issue warrant to the bank manager. No way out, because we cannot decide on the basis of the pleadings.
exactly.
Here also we cannot decide.
Here, another aspect is there. The permission was granted by the town development. Development.
Now, development authority is a party.
Yes. Development.
Who represents development authority?
Nobody is there.
Yes, state.
Service completed, madam. But there is a direction from this honorable court to dispose of the matter by the municipality, my lord.
Huh.
So municipality, my lord. Now they are the authority, my lord.
Yet we
But
have
they
said-
said, my lord, what they says, I cannot trust my predecessor order. Can it be, my lord?
No, that's the total, my lord, mistaken view.
Hmm?
Eh?
The
My
view
lord-
expressed by the chairman is totally a mistaken view, because he should not have sent that way. And on the top of everything, my lord, if the permission given by the Silchar Development Authority, if there is some mistake, you have the right to make it correct in terms of the building bylaw.
Of course.
You can't say that.
And some certain things can be corrected, certain cannot be corrected.
Yes.
Yes, in terms of the bylaw. And I think is this that case that there is specific date? This is not the case. No? Now, what to be done? Please tell us.
Development authority, apni उपयोग है
Development तो more নহয়. That is only-
2 to 5 भी लिखा है.
so wrongly listed.
It can be sent back.
No, Mr. Datta, problem is this. We do not want to create an embarrassment for an authority.
Yes.
But if we are compelled, we'll do that. We are giving you a time, we cannot compel you also.
My lord.
Because it is there, they have not engaged you,
Right.
but taking note of the situation, you are a senior counsel. So therefore, we made an out of turn request to you. So if you can have it,
Batting campaign आजकल नहीं ना पूरे फिक्स लेके रखूंगा
you can advise them at least that this is the way, or you can express the view of this court. If thereafter they are silent, then we'll do.
Milord, your lordship can do one thing. It can be fixed on 24th of this month. And in the meantime, I'll have a interaction with them.
Okay, Mr.
Mal-
Mahto. Okay. In terms of this court's earlier order dated 11/9/2024, Mr. Datta, Learned Senior, Dr. Learned Senior Counsel is present, and he submits that he may obtain instruction in this regard, and therefore matter may be fixed on 24th. Prayer is allowed.
Obliged.
It is recorded herein that in spite of receiving notice, the Silchar Municipal Board and Silchar Development Authority has not entered appearance, and in the aforesaid backdrop, this court has made a request to Mr. Datta, Learned Senior Counsel, to have instruction from the Silchar Municipal Board, for the reason that generally in other matters he represents the Silchar Municipal Board. Full stop. Let's
There is an interim order.
interim order pass earlier shall continue till the next date of listing.
Obliged.
Yes, Gogoi.
My lord, the appeal is lying unattended. Due to the fact, my lord, there is a rule which says
the person has to give a prescribed fee of 2,000, he has given, but he has to pay 25% of the amount which is under dispute, my lords. Rule 70 of the AMMC. law. And cancel, termination order of 13(3) is 24 is under challenge. And he has been found defaulter of a amount which will find in page 163. Is
Hmm.
32,53,091 rupees.
Hmm.
So that the statute says, my lords, 25% has to be deposited.
Any exemption of that? Under the provision of that?
That I cannot say, my lords.
No,
Statute provides.
no, no.
I am against my cancellation order, my termination order, I mean, there's a statutory appeal, my lord. All right, on that ground, they can dispose of it, but this is regarding, my lord,
No. Reason of termination, reason of the foundation of his termination is because of default. So meaning thereby, my lords, the default amount, if he pays also. he has
No,
to put the-
what the rule says, appellate rules. Tell her, read it.
Rule says, my lords, no application for review or appeal shall be entertained in matters where the applicant is in default of any government dues.
Hmm.
On whatsoever account, unless he deposits at least 25% of such dues before filing such application, and a proof of such payment is enclosed with the
So you
application.
want
of
to
amount.
say, since the ground of termination is default, therefore this will be applicable.
Yes, ma'am.
We'll examine this.
My
my
lord.
lord, my lord. Because during COVID period, everything is in 2 years, my lord, because of
I've
the
seen that,
COVID, my
that's why,
lord.
that's why. Let us see whether we can exercise
Yes,
our
ma'am. Let-
reach
formally-
jurisdiction.
My lord.
Heard, Mr. Mo, at least we are clear why this.
Yes, correct.
Instead of sending it, we could have disposed it of. Instead of sending, then they will say,
Yes.
because there is a rule, High Court has passed this. If we
Fine.
pass at all, we'll pass a reasoned order.
My lord.
So let them file. in
The
affidavit.
present application is filed. Present writ petition is filed.
Against the termination order of
Termination 13/3/24.
Assailing an order dated
page 130.
30/12/2017. No,
No, 13/3.
13/3/24.
2024.
Yes,
Lordship
termination
find it page 130.
130.
Terminating the license or
Please, my lord.
Lease,
mining lease
mining lease of the.
granted to the petitioner on the ground of default. Full stop. The petitioner has filed this petition also with an additional ground that the appeal preferred by him has not been attended till date. Full stop. On instruction, Mr. Gogoi, learned standing counsel for the Forest Department submits that the petitioner has not deposited the 25% of deposit, 25% of the default amount, which is mandatorily required under
Rule 70, my lords.
Rule 70,
70 sub 2
70 within bracket 2
of AMC.
of
Assam Minor
Assam
Mineral Rules,
Minor Minerals Concession Rules 2013. Full stop. Let
them
a
file in affidavit.
notice be issued,
Lordship,
returnable on. Give a date. After vacation,
After vacation.
Give a
the
date.
fixed date of the date.
returnable on.
November, my lord, 10/12/12.
11th of November,
My lord.
2024. In the meantime, the respondent may clear their stand by way of an affidavit.
Deeply okay.
My lord. Obliged.
Yes,
Lord, Your Lordship, my senior counsel has instructed me to pray for a shorter date.
okay. It is submitted by the learned counsel representing the respondents that the order dated 24/7/2024. Oh, no, order dated, is that it 24/7, order passed in WPC 3390/2017 has already been complied with. Full stop. The learned counsel for the petitioner prays for 2 weeks' time to obtain instruction from his client. Prayer is allowed. Please this matter after puja. Yes, what is your instruction?
My lord, your lordship directed me to obtain the rate
Uh.
quoted by the petitioner as well as the present rate, my lord, that has been supplied by the present supplier. The present rate is, my lord, rupees 153.04
Hmm.
with GST.
And his rate?
His rate is 117.60 including GST.
So allow him to supply with 154.
My lord, may I submit only one thing,
Yes.
my lord? In the IA also, they have annexed one letter, my lord, at page 11, my lord.
Hmm.
Annexure 11, page 17, my lord, by which by letter dated 18/7/2020.
The earlier that person who is supplying at 154 also participated in the tender process.
Yes, my lord.
He was unsuccessful.
Yes, my lord.
So
No,
give
my-
a sanctity to the tender.
My
process.
lord, only one submission, because my lord, by letter dated 18/7/2024, he has been asked, my lord, if your lordship.
He had been asked to do what?
My lord, to have a negotiation or talk with the authority, my lord.
Uh.
He was called to have a talk with the authority, my lord, regarding the rate, my lord.
Uh.
So let him come once, my lord, let them have a talk, my lord, then they can proceed, my lord. Because there was a direction from the Director of Medical Education, my lord. Because
Saying
the
what?
petitioner has not initiated all these on his own, my lord. The matter was referred to the DME, my lord. DME asked the petitioner to constitute a committee. Accordingly, a committee was constituted. And that committee, my lord, in terms of the
On which date they will go and meet you in your chamber? Tell us. Nothing extraneous. Yes.
yes, my lord.
When which date?
Any date within 1 week.
Have an instruction. We are passing this order tomorrow.
Yes.
On which date he will appear before you and have a
But-
negotiated settlement. And
Which
we'll observe that when there is a tender process, the existing person's tender has been rejected.
Yes.
It will be interest of the thing to give a sanctity to the tender and allow the successful bidder at the rate as you desire.
My lord, within 5 minutes,
May-
I will tell. Within 5 minutes. I will-
5 minutes, take your
Yes, yes,
instruction.
my lord.
In the highest rate in the whole Northeast law.
My lord, rule, if I may bring your lordship to rule two
Tell us,
ninety-five.
tell us.
295 lordship talks about objection from local bodies.
Hmm.
And from following persons will be considered. Lordship, I was informed that since in BTC they do not have local bodies,
Hmm.
the prevailing practice is that the BTC authorities grant NOC instead of lordship the local body.
What it rule says, read it.
Objection from 295, objection from local bodies and from following persons will be considered.
At what stage? Tell us the stage. We know that. Tell us the stage.
Ascertainment
What
here
is the stage?
before setting up, lordship.
Before the permission is granted by the excise superintendent and amount is due. That stage is gone.
That is NOC, I have enclosed, my lord, page
That stage is gone.
37.
You cannot put the things back. Keep your sanctity intact. Yes.
Lordship, here I have it, the instruction. His application has been rejected by the authority.
Who?
By the joint secretary. He submitted a representation.
Who has rejected?
The joint secretary.
Where is your authority?
Lordship, the superintendent of Texas has forwarded the.
No,
proposal.
understand. Please understand, Mr. Chaudhary.
Yes.
Excise is not a transport subject.
It is not.
Excise is not a transport subject. Now, so far relating to Mr. Borthakur is concerned, he says that since there is no local authority, we insist on a no objection from the local authority from the BTC authority in terms of so and so. Okay. Now that stage is prior to sanctioning of the license, prior to approval. Then once it is approved, then there will be certain other stages where you will have to deposit money and all. Now that has been done. Everything is done. Now can BTC now say that we have rejected. And even if you rejected, is there any validity or any relevance of that rejection? Yes, you act.
Lordship, as per our instruction, only a representation was sent to state excise, but all these documents, Lordship, annexed in the writ petition, those were sent to BTC authorities, Lordship.
See, Mr. Bhattakur, please understand. Who is the authority?
Excise. Yes.
Excise is the authority. When is the NOC is required from the BTC?
After excise grants.
Before excise takes a final decision.
Lordship.
It's not only for the BTC. A rule applies to everybody. Then there may be school, there may be objection by local person. It likes that authority, and thereafter the commissioner will decide that whether will grant license or not. That stage is over. Amount is deposited. Now, somebody files a representation before the Lotus Hill Police Station against the Registrar General of Guwahati High Court. It's a serious business. Because statute gives some power to some authority. And that authority, statutory authority, can be made subordinate to an non-existent authority. And can that statutory authority say, we will not exercise our power because of the objection of that authority who is now having no role under the Excise Act? Or if you say that, yes, we are helpless, statute is forget about the statute, or you amend the statute, transfer the subject to BTC, let the BTC authority decide whom to give, whom not to give. When? With interest, payment, cost, everything will impose upon excise, not upon BTC. Since you are acting, BTC has no role.
Lordship, if I may suggest, let the Commissioner of Excise
No, we'll not pass such an order until and unless we say that whose power is what. We'll not relegate like a post office, as simple as that. Today time may not permit to
Page-
pass a judgment.
Page 17, Lordship may see, man.
Page 17.
17. This is by Deputy Commissioner to the Joint Secretary, nothing adverse.
No,
Last
that
line.
is one, but you have deposited the amount also.
Yes, deposited the amount, inquiry over, and
Everything is over.
during inquiry, 3 NOCs have been, they asked for 3 NOCs, all the NOCs are enclosed now. NOC by municipal board, NOC by
It is a question of law.
local body.
No affidavit is required. Yes, BTC file an affidavit.
Yes, ma'am.
When? Because you have your instruction, you
Yes,
just
sir.
bring on record that this has been, we'll delete it.
Lordship, week's time.
Huh?
1 week.
No. 1 week.
1.
1 week is fine. Yeah, they have exercised their authority beyond jurisdiction. It's an excise, something different. It's a constitutionally prescribed procedure is there. On the basis of that, Excise Act is enacted. Power is not transferred to BTC under 6th schedule. How can you decide? Learned Standing Counsel for the BTC, Mr. P. Chaudhuri submits that he has received instruction and would be able to file an affidavit within a period of 5 days from today. Accordingly, matter stands adjourned. List this matter on 4th of October. You have this, Bhattakur, register to reflect this name. You will have to, because 4th will be a very rush day. You will have to show us the procedure, stages of procedure, how to apply, what are the objects, statutory requirements, and then Mr. Chaudhary, you'll have to enlighten
Yes,
your power under the Excise Act and the rules plan we are under.
Yes.
If you can show that, yes, this power is delegated, we are having the power, that is fine. We will say that, yes, your objection, we'll ask him to challenge your NOC. That's all. If otherwise you don't have any authority under the statute, your rejection of NOC will be no relevance under the scheme of that. And therefore, we'll say that it is not required to be challenged until and unless you can show that this is our power, accordingly we have exercised. That's all. And what about advise your client? If you want to surrender, you can surrender. When?
My lord, any day, tomorrow or a day after tomorrow, except Saturday and Sunday, my lord.
Tomorrow, Lordship.
Okay.
Tomorrow we'll go. The
Pursuant,
second half, Lordship, because he have to come from Dibrugarh.
day after, then we'll make it not to.
Lordship,
Yes.
Lordship.
Pursuant to this court's order dated 11/9/2024. You just write down the paragraph 1 of 11/9, paragraph 2. Pursuant to this, then pursuant accordingly, this court asked Mr. Bora to obtain certain instruction. Then paragraph 1, 2, 3. Mr. Bora has obtained instruction to the effect that the authorities are interested in having a negotiation with the successful bidder, that is the petitioner, so far relating to the price, in as much as according to the authority, the price quoted by the petitioner may result in supply of poor quality of dietary articles. Full stop. Dietary articles. Articles. At this stage, Mr. Sharma, learned senior counsel, submits that petitioner is having no objection for any negotiation, as he is admittedly the successful bidder. Accordingly, so full stop. Mr. Bora further on instruction further submits that the petitioner may visit the office chamber of respondent number 3 for such negotiation.
4, my lord.
On respondent number 4 for such negotiation at 2 p.m. on day after tomorrow. 28 of so and so. In view of the aforesaid, this court has restrained for passing for any further order, and accordingly provides the parties to sit over the matter and settle the issue. Full stop.
My agreement is already given as per the
Okay,
JMEA Lordship, that is at page 7.
We are not saying anything. You haven't come back. Accordingly, list this matter on 4th of October for consideration of the interim prayer, consideration of the IA, if so, if necessity arises.
My lord, kindly a copy of the order maybe.
A copy of the order be, just you do it today itself. A copy of the order be
Lordship can bring it on 3rd, Lordship. It is the last working day.
on 3rd of October.
Yes, my lord.
On a copy of the, Mr. Bora is permitted to download a copy of this order to for purpose of forwarding the same to the respondent number 4.
Actually, my lord, last order has not been uploaded yet, my lord. I could not download it.
What
I
you
could
say?
not communicate. That's why I am praying, my lord, so that I can communicate with the order, my lord.
No, Lordship, it is uploaded, it is in the IA, Lordship. It is
Okay.
there. I have the copy.
Why? Yes.
This was passed in IA.
It is
Yes, yes.
uploaded in the IA.
Yes, my sorry, my lord. Yes.
I have downloaded.
I was surprised because
No.
see, sometimes it takes sometimes in some long orders,
Yes, yes. my
2-3
lord.
days we accept that takes, but
No, it is uploaded in the IA.
Yes. That's
don't-
why I could not.
We have downloaded, Lordship.
God bless me, lord.
There are similar orders, Your Lordship. I have.
But what is the present thing
Lordship.
as provided in the division bench? It should be allowed to continue as per existing. What is the existing?
Existing Your Lordship who are running, they will run Your Lordship. So far as in my case is concerned, Your Lordship, we are not running.
You are
So
not.
Your Lordship, we are only challenging the tender notice. Your
Okay.
Lordship. And tender notice, since the issue is before division bench, Your Lordship, and coordinate bench has already stated the another tender notice specifically same. That is at page Your Lordship.
Heard Mr. Botakur, learned counsel, and Mr. I forgot his name. Mr. Huh?
Is for one.
You are for one and Mr.
I am
Chotil
for 2 and 3.
2 and 3. Give who are referring to. The petitioner is aggrieved by an NIT dated
19/8/2024.
19/8/2024. 19/8/2024 on the ground that such NIT has been issued in violation of different provisions of the targeted public distribution system within bracket control order 2015 and targeted public distribution system not that is targeted distribution order 2015. Fundamentally, it is the case of the petitioner that petitioners are Gao Panchayat Samabhai Samitis and transportation of food grains are now being sought to be given through the transport contract for transportation of food grains now is sought to be given awarded to private player in derogation of the aforesaid control order and depriving the Gao Panchayat Samabhai Samitis.
Not only the private players, my lord, the GPSs can also, my lord.
No, you are bring to include depriving earlier it was there only. Now you have was trying to bring in therefore I say. Okay. In similar circumstances, coordinate bench has passed an order to providing that the transportation, lifting and distribution of food grains from designated depots to be carried out as per existing system of distribution on the basis of an order passed by division bench in WA number 249 of 2018. Full stop. Accordingly, Mr. Botakur praised for a similar order. Full stop. This method needs further consideration. Issue notice returnable after 4 weeks. So and so accepts notice. So and so. All are represented as the parties are duly represented. No formal notice need be issued. However, extra copies requisite in number be granted to the furnished to the learned councils representing the respondents. First up, in the interim, it is provided that lifting and distribution of food grains from the designated depots. So far, the same relates to the Gao Panchayat Samabhai Samitis under Dhemaji district be carried out as per existing system of distribution.
And I think maybe state your, otherwise they may your lordship. Here your lordship and I can state.
Be finalized, madam.
Okay, the comma in view of the, it is further provided that the respondent authority may proceed with the NIT. However, same shall not be finalized without leave of this court. First of, it is further provided that the petitioner may also participate pursuant to the standard.
Cannot, your
You
lordship.
cannot, okay. Okay,
Since
no,
your lordship, they have your lordship, there are conditions your lordship
Okay.
which virtually outside.
Okay. Okay, the last part is not. Yes.
Obliged.
Yes, the respondents were directed to file malad affidavit
Hmm.
and also produce the record with regard to the technical. Well, short issue. In fact, so far as the first writ petition is concerned,
Hmm.
that was preferred by the writ petitioner for cancelling his technical bit. On
Okay.
the ground that my lord, so far as one work experience is concerned,
Hmm.
he placed a my lord completion certificate
Hmm.
of Arunachal Pradesh by working as a subcontractor there.
Hmm.
Now, my lord, when we sought for clarification from Arunachal Pradesh,
This is item number?
51. In
Okay.
item 51,
Okay.
there, my
So
lord, they,
you sought for a clarification then?
yeah, they informed that, my lord, as per their tender conditions,
Hmm.
in order to sue a subcontract, my lord, prior permission from them should be taken.
Hmm.
That was not there.
Okay.
So that particular.
So
bit-
they did not recognize him to be a
Yes, that, so, my
subcontractor.
lord,
That
in
is,
Borpeta, when the petitioner participated some other tender, it was rejected. His
Ah.
technical bid was rejected. Now, in the present case, item 50,
Hmm.
on the same similar ground,
Hmm.
considering that clarification, again, it was rejected.
Hmm.
But by this time, the petitioner has brought that, my lord, clarification, that, my lord, ex post facto recognition or approval from the Arunachal Pradesh.
subsequent.
So it was regularized, but
Okay.
despite that, my lord, it was cancelled.
Ah.
Challenging that, the writ petition was filed,
Hmm.
item 50.
Hmm.
During the pendency, my lord, the financial bid was open.
Hmm.
Now it came to the knowledge of the petitioner very candidly, my lord, fairly, he
He's-
submitted
he's-
that he is otherwise also, if he succeeds, he will be L2.
Hmm.
So honorable court directed us to proceed with that particular
Ah.
tender. And on academic discussion, my lord, this issue will be dealt with in a subsequent time. So it was kept pending.
Hmm.
Now the second writ petition was filed, that petitioner on the ground that he has participated in 3 more, my lord, tenders.
Hmm.
And he apprehends that, my lord, on a similar ground, they are also in those 3, my lord, tenders, my lord, it will be rejected.
Hmm.
I made a, my lord, commitment as per instruction of the authorities that, my lord, on this particular ground, we will not be rejecting him.
Hmm.
That is in the interim stage.
Hmm.
So honorable court directed us to proceed with the technical bid, but not to finalize it.
Hmm.
Though the start has been prepared, we have found that, my lord, in the out of the 3 tenders, 2 has been opened.
Hmm.
There, my lord, we have found that there are 5, my lord, discrepancy against the present petitioner.
Hmm.
Forgetting, my lord, that part, that,
Hmm.
my lord, which is pending, my lord,
Okay.
that Arunachal part.
Hmm.
So, my lord, I pray, since, my lord, there are, my lord, 5 grounds of rejection, apart from that Arunachal case, my lord. So I may be allowed, my lord, the authorities may be allowed to, my lord, at least upload the technical bid, because other parties are, my lord, waiting.
Okay, now tell us, what is the work?
My lord, these are 3 works, my lord, regarding construction part. Now, my lord, the construction season will start, my lord, rainy season is over.
That's what you say.
I will place the, my lord, minus. My lord, only his apprehension is that, my lord, if he can, my lord, have that particular subcontract,
Hmm.
his work, my lord, value will be, my lord, higher. He can participate in other bids. That is his entire intention of filing this 2 writ
So
petition.
that you have already considered that we
That
will not
was
reject, and
possibly
this time
decided
also it
with
is
very short issue on that point. But so far as these 3, my lord, tenders is concerned, since 2 we have already opened.
3 tenders. what
One
you
we have
say?
not opened, my lord, because some technical reason, my lord, the technical officer was not there, it could not be opened. 2, my lord, minus I have, my lord, I will file one affidavit, but in the meantime, lordship will allow us, just lordship may kindly see. There are 5 grounds of, my lord, rejection. So these 2, my lord, tenders, lordship may kindly allow us so that we can proceed. Because otherwise also, my lord, that he will have to challenge it, my lord, if moment we finalize it, if he wants to challenge those grounds, my lord. In the second page, lordship will find the grounds.
What is his name? Tanor.
Tenor. So A, B, C, D, E. If 2, my lord, these 2 parts are, my lord, allowed, my lord, at least we can upload the technical bid in the JAM portal. Then the petitioner can also, my lord, go through it, and if he find something, he can challenge it, my lord. There is no bar to that.
Yes, what you say?
My lord, the whole issue, my lord, with regard to the acceptance of the, my lord, the work expense certificate that have
Yes.
been issued by the Arunachal Pradesh.
No, that is no more.
That
no.
can be decided, my
This-
lord, later. It's not that, my
My
lord.
lord, with that observation, if even the writ petition can be closed, my lord, if any, my lord, this particular, my lord, work expense certificate, the rejection ground
they'll not stick to it in any other, my lord.
No, that lordship will decide in the first petition. It has been kept pending. Though my lordship.
Now,
has
would
allowed
you
us.
do one thing? Let them upload
Yes.
this.
Yes.
If you want to challenge, you challenge it
No, that
immediately.
is, yes, my lord, that can be done. my lord.
Okay,
That is,
That's
my
why,
lord,
that's the limited prayer today I have.
We are not closing this petition.
Yes.
Will, your apprehension, we understand.
Yes.
That if we say that this can be treated as a document certifying your experience,
Yes.
matter ends there.
Lordship.
Is not it? That
Lord,
part you want to,
That affidavit only requires, my lord.
No,
for
then, my lord, item
decision.
50, I will file an affidavit on that
Okay.
particular point. So
Okay.
far, the second case, lordship may allow us to proceed. my lord.
okay.
Only with regard to two, my
Two
lord,
works, two works, yes.
where
These two
technical
works.
evaluation has been done.
Heard
There
Mr.
three works
PJ
have been
Sekia,
mentioned.
this is item number 4089.
No,
No, no,
4043.
4406.
4089, what should we do?
Well, lordship will direct us to
Okay.
file an affidavit.
Okay, Mr. Gogoi, learned counsel for the petitioner. Submits that he may be granted. How much time?
It's
My
for
lord, that-
respondent.
Respondent.
Let it be 2 weeks, my lord, after vacation. lordship
uh,
post-
The thing
On
is that, my lord,
23rd.
Lordship will see, my lord, the time and again and every time.
Then, my lord,
that
1
will
week.
take-
my lord, I will
Okay,
file it. I will
okay.
file
Let
it.
it
He
be,
just
my lord,
filed it.
shortly.
A week's time to file an affidavit to the limited issue whether the certificate,
Work experience
work
certificate
experience certificate
in compliance of clause 2.2.2.2.
in compliance of clause
2.2.2.
2.2 can be treated as a disqualification. Cannot be treated as an work experience.
Yes.
Can be used as a work experience as the issue revolves around that fact only.
Lordship,
Prayer is allowed. List this matter on
any day, my lord, before vacation, if you have some urgency.
Third.
Short issue, my lord.
third.
The notice, my lord, the tenders. have been
There was
filed,
the
so I have been
irregularity, my lord.
participating.
I have also seen it, my lord. It has been regularized now. We cannot question the owners of government now. That's why you have issued
3rd of October. Now next case.
next case.
Next case. Heard Mr. PJ Sekia, learned counsel and for the senior counsel for the petitioner, assisted by Mr. KJ Sekia, learned counsel, and Mr. Gogoi, learned counsel,
PWD, my lord.
learned standing counsel for the PWD. Full stop. This court write down paragraph 2 of 29/2024. Full stop. In the aforesaid background, this court though permitted technical evaluation of the NI bid in question. Bid in question. However, experience clause was directed not to be adhered to as far as the petitioners are concerned. Petitioners is concerned. Full stop. On instruction, Mr. Gogoi submits that the experience clause without even considering the without even adhering to the experience clause, the technical committee evaluated the bid and the petitioner was found to be non-responsive on other aspects also.
Yeah.
And therefore, they may be allowed to upload the decision of the what do you call it? Decision of
Technical
the
evaluation.
technical bid evaluation committee in terms of the procedure prescribed under the NIT. Full stop. Mr.
Hello, where technical evaluation has been done, there are 3 works, they have done.
Two they have done, two works. In view of the aforesaid, no, Mr.
My lord. Lordship will
Sakya.
indicate the works, my lord, in the order. So that, my lord, we can
Give
open.
the works.
No, it's in the heading, my lord, it has been mentioned. In
Okay,
those minus-
come on, technical
In the
evaluation
minus
committee
it is
so
written.
far relating to improvement of NH 44 within bracket new NH 08 from kilometer 273,000 to kilometer 277,000. And where is the other one?
In the next bunch, my lord, 2 minus I have given.
Okay, and seat, and so and so, so and so has already been completed and uploaded. Mr. Sakya, learned senior counsel submits that as his experience certificate is not adhered to, he will not object uploading of the technical bid subject to his right to challenge such technical bid. Full stop. In view of the aforesaid, the respondents are permitted to upload the technical bid subject of a technical bid. Full stop. It is made clear that petitioner shall be at liberty to assail such technical bid if so advised.
The affidavit shall also be filed.
Okay, that we have passed in the other, huh?
First one we file an affidavit.
First one that we have said. Okay, these two, huh? Two works, okay.
Obliged.
List on, list along with WPC 4089/2020.
But can I retain those minutes, so that I can bring it?
No, you can be retained, but for his
Yes, yes.
typing,
But then
after
let it be
some
for-
time,
for-
she will hand it over,
Lost.
or maybe tomorrow.
Lost. Obliged.
Yes. Where is MK Chaudhary?
Lordship,
I wanted the judgment, we will not hear it today,
judgment we have.
that division bench judgment. We are dictating the order, but I want to know this, because we are issuing on a first part. So we'll just, because of this, somehow we missed it.
Lordship was a single judge order.
Single judge order, we are
This is the division bench one.
Huh? Decision.
Division.
Okay. Okay. List this matter on 4th of October.
For delivery of orders,
Huh?
For delivery of orders, Lordship. Further hearing, Lordship.
See, we have decided on that point that if we take the first point in your favor, matter ends there. We do not know till now. And in his favor, then we'll, on that day, it is, we will keep it as a further hearing. If we are in your favor, then it will be disposed of, oral judgment will be there on that date.
Lordship.
Okay?
Lordship.
May I please, no?
Yes.
Last of all, I was directed to file an affidavit. But certain developments in going on the same.
What development? Okay, Mr. Dr. Learned Standing Counsel for the Revenue and Disaster Department has, on instruction, submits that the issue as regard inclusion of post Rajbangsis as protected class in a tribal belt and block of Assam is going to be placed before the cabinet, and therefore he seeks an adjournment to file a comprehensive affidavit. In view of the aforesaid development, the prayer is allowed. List this matter in the first week of November 2024.
Logic, obliged.
List last, na? We have awaited you, keeping you awaiting.
No, my lord.
See, if you start a hearing, that's why I've asked it, are we going for final disposal? If final disposal, then you need
No, my lord.
no anxiety that some other methods are
Item 21, my lord.
item, you will argue in item
21.
that is WPC
6416.
64176, okay. Where is the CGSC?
Sir, Miss B. Sharma is there. She is on leave-in under, but I have informed her.
Lord, this is second round now, the litigation.
Hmm.
In fact, the issue is really very soft.
Hmm.
You know, a Northeastern promotion policy, industrial policy was announced in the year 2007.
Hmm.
And you'll also find at page 44,
2007, isn't it?
my lord. Oh, no.
Mr. Dr. Saraf, you will take how much time?
But I don't
Half an
think-
hour?
Yes, my lord. Oh, no, somebody- And you'll also may kindly see,
Hmm.
there was a negative list also at page 46.
Is 46. Yes,
I will take you also to clause 10, Roman 4.
clause. Clause 10,
Roman
Roman 4.
The
Good,
following industries will not be eligible for benefits under the NEIP 2007.
Hmm.
Now, what is the industry?
just a minute, Mosami,
For
a different color pencil.
goods falling under chapter 27 of the first schedule to the Central Excise Tariff Act 1985, produced by the petroleum, oil and gas refineries.
Clause, goods under 26, produced by petroleum, oil or gas
Refineries.
refineries. Goods falling under chapter 27 of the first schedule, the Central Excise Tariff, produced by the petroleum, oil and gas refineries.
My lord.
Okay,
So only when the goods are produced
by petroleum.
by petroleum gas industries, refineries,
Hmm.
the same will fall in the negative list.
Okay,
Now, admittedly, all the petitioners, they are neither the petroleum, oil or gas refineries.
Hmm.
Now, in pursuance to the industrial policy, my lord, the petitioner applied for the registration certificate,
Hmm.
which you'll also find on page 54.
page 54. Page 54. Just a minute. Yes,
This is certificate of registration under the NEIPP 2007. Messrs. So-and-so is hereby registered under the Central Capital Subsidy Scheme,
Hmm.
Central Interest Subsidy Scheme, Central Compensation Scheme, and the common registration number allotted to it under so-and-so is so-and-so.
okay,
Similarly, my lord, the petitioner got itself registered under the Central Excise Act at page 55.
okay. Yes,
And thereafter, my lord, there was also a Central Excise exemption also.
Hmm.
So that exemption was also granted, which you also find page 57.
page 57.
My lord.
Hmm.
Relevant part at page 61.
Sixty-one.
In view of the above, I determine a phrase that so-and-so is a new industrial unit established on or after 1st April 2007, situated in so-and-so, and commenced their commercial production with so-and-so, have fulfilled the conditions laid down in the notification number so-and-so, as amended by notification number so-and-so, and eligible for the benefits of Central Excise exemption for the so-and-so. These notifications were issued in order to give effect to the industrial policy
Policy.
regulations. Now, the petitioner submitted his claim for central investment subsidy before the authorities. But at page 63, you also find
Yes,
a clarification was sought for from the, by the additional director, Commission of Industries from the Joint Secretary Government of Assam.
Mm.
And you'll also see says, number 2, point number 4 of the negative list reads agenda, that is I have read, my lord. In respect of calcined petroleum coke, which is the major raw material, is a refinery product. The question of eligibility of transport subsidy has been raised by the audit against the providing of transport subsidy, stating it to be refinery product.
Mm.
The matter of eligibility of subsidy under so-and-so to bitumen expulsion, for which the major raw material is bitumen, is refinery product, was discussed in the meeting, a state level committee constituted under so-and-so, and it was decided to refer the matter to so-and-so for clarification.
What is DIPP?
Hello? The
Refer the matter to the DIPP,
Director of Industrial
policy,
Promotion Policy.
promotion and policy, okay.
So now they are saying, that the major raw material
Hmm.
for production of calcium petroleum coke and bitumen is refinery product.
So therefore,
Therefore, it will fall
so
in
they have deleted the by.
produced by.
Produced by is there deleted, they say that any product who uses it as a raw material, refinery products is not
So
entitled
that was
under,
very confusion, so they sought for the clarification
from
the
the
General Secretary.
DIPP.
DIPP.
Now, what is the policy? DIPP is the policy maker.
No,
Policy is made for who made this
Government of
policy?
India.
Government of India. Okay.
Now,
Now,
the matter was referred to the Government of India at page 64.
Hmm.
For clarification,
yes.
and ultimately
Hmm.
at page 66.
Hmm. Is 66.
My lord. The office memorandum is there.
Hmm.
By the
Page
minister.
64.
64, 5, my lord.
66. 66.
I'm sorry, my lord, 65.
65 is the office memorandum.
A clarification was sought for.
Hmm.
You'll also see para 3.
Hmm.
Department of Revenue is requested to clarify as to whether industrial units engaged in manufacturing calcined petroleum coke and bitumen expulsion can be treated as an eligible unit for excise duty exemption and other benefits under the Northeastern Investment Policy 2007, specifically in view of Chapter 27 of First Schedule of the Central Excise Act.
Hmm.
By giving it to the negative list.
Hmm.
The Government of India sought for a clarification from the Revenue Department.
Hmm.
Now, the Revenue Department gave a clarification at page 66.
Yes.
It says, my lord, the undersigned is directed to refer to the so-and-so dated so-and-so seeking clarification on whether calcined petroleum coke can be treated as eligible for excise duty exemption and other benefits in Northeastern so-and-so promotion policy, especially in view of para 4 of so-and-so of the so-and-so policy. Exemption from excise duty has been extended to the excisable goods manufactured in the Northeastern states based on the NEIP 2007 under notification number so-and-so. However, the benefit of excise duty exemption has not been extended to goods listed in the negative list mentioned in so-and-so of the policy. Calcined petroleum coke is classifiable under tariff item number so-and-so of the first schedule to the Central Excise Tariff Act. Hence, if the product is manufactured by a petroleum oil or gas refinery, it is clear that the benefit of excise duty would not be available. Can you note it, my lord?
Manufactured by petroleum and gas industry.
So they say that if these products are manufactured by the petroleum oil and gas refineries, the exemption will not be available. However, if they are manufactured by a stand-alone manufacturing starting with the raw material other than the crude petroleum or natural gas, that is by manufacture other than the petroleum gas or gas refinery, the benefit of excise duty exemption would be available. So they made clear, my lord.
They say that if it is a standalone manufacturer,
My lord.
starting with raw material other than crude petroleum or natural gas.
My lord. So the negative list only say that these items when produced by the
Two
petroleum oil-
conditions now, if I have correctly
My- my-
understood.
my-
One is that it clarifies that if it is manufactured by a petroleum, oil or gas refinery, it is in the negative list. And second condition is if it is by a standalone manufacturer, it is entitled, but the raw material other than crude petroleum or natural gas.
Image, I
Hmm.
mean, just
Hmm.
say, there the item, negative list item is there, that the item must be falling under the chapter.
That's clear.
And it must be produced by the oil.
Oil
petroleum
and gas.
refineries.
No, this is their
My
explanation.
lord, it's absolutely good, but petroleum oil cannot be manufactured, my lord, by the,
Mhm.
now, the matter was forwarded to so-and-so, page 64, 65, 66. Now, your lordship, my representation was submitted
Hmm.
at page 67, 68 to the Joint Secretary, Department of Industrial Promotion Policy.
Hmm.
Because the matter was pending.
Hmm.
Similar representation was submitted at page 68.
Hmm.
The petitioner was granted the from Collision Control Board,
Hmm.
the consent to operate at page 70.
I think they are not disputing all this.
So for consent to operate will be necessary because now they are taking some other ground, you know.
Other ground,
They are
in
now
the affidavit.
in the order again, because matter came up before this honorable court earlier. Then it was remanded back. Then again, they have passed their fresh order
Hmm.
where they are taking some other grounds.
Okay.
Now thereafter, my lord,
Hmm.
the
Page 70.
page 70,
Hmm.
the consent to operate was granted by the Pollution Control Board.
Just a minute. Okay, page 70.
I'll give a list of dates, my lord,
Hmm.
synopsis to your lordship.
Mhm. Consent to operate. Okay.
Then at page 74,
Hmm.
I was informed by the District Industry and Commerce Center, copy of which commission was marked, that the SLC had decided to keep the matter pending till the clarification comes from the central government.
Page 74.
74,
This is by General Manager, District Industry Center.
addressed to the Commissioner and Secretary. A copy was marked to me.
Okay.
Then again,
Now-
I submitted representations. I am not taking the lordships for that.
Hmm.
At page 79,
Hmm.
the clarification came, my lord.
Page 79.
My lord.
Hmm.
It says below, the undersigned is directed to say that subsequent to announcement of a package of incentives and concession of Northeastern region, namely Northeastern Promotion Policy, a reference has been received from the state government of Assam seeking clarification whether units engaged in manufacture Karsan petroleum coke and bitumen are also eligible to subsidy under so and so. The matter has since been examined in this department, and it is clarified that the units engaged in the manufacture of CPC and bitumen emulsion fall under the negative list of 2007, since raw materials used for manufacture of both CPC and bitumen are byproducts of petroleum refineries and hence not eligible for subsidy so and so.
Okay.
So now they are saying, they said, Miller,
Hmm.
that since the byproducts of the final product
Hmm.
were a refinery product,
Hmm.
and thereby they will fall in the negative list.
Hmm.
Below again, the representation was submitted.
Hmm.
And ultimately, the matter was carried before this honorable court.
Hmm.
And here, page, you'll also see page 88.
Hmm. Page 88. Yes.
I'll take you also to the relevant part.
Hmm. Hmm.
There are 14 at page 99,
Page 99.
my lord.
Just a minute.
Para 14, my lord.
Para 14.
My lord. I may read. The respondents have also filed a rejoinder affidavit with the following statement. As per circular dated so-and-so NIP, goods falling under chapter 27 of the first schedule to the Central Excise Act have been placed in the negative list for benefit under the said policy, and the CPC has been listed as one of the goods under chapter 27 of the first schedule to the Central Excise Act 1985. A above quoted stand of the respondents in the rejoinder affidavit is somewhat misleading, inasmuch as while stating that the CPC has been listed as one of the goods under chapter so-and-so first schedule of the Central Excise Act, the respondents have conveniently ignored that it is only the industries engaged in the goods produced as petroleum, oil, or gas refineries. Further, if you go by the stand of the respondents in the counter affidavit, no conscious decision in the matter is discernible. In one place, they have mentioned that if the particular product is manufactured by the petroleum, gas, or coal refineries, the benefit of excise exemption would not be available. But in other place, they have contended that the production of the coke has the adverse effect on the environment. Finally, without placing on record the reason, the respondents have conveyed the proposed conclusion referred to in para A9 of the counter affidavit that the units engaged in manufacture CPC and bitumen expression qualify in the negative list of 2007. As referred to in the affidavit reply filed by the petitioner in the affidavit opposition filed by the Central Collision Control Board in PI number so-and-so, it was specifically contended that there will be no adverse effect, no effect of pollution caused by the CPC producing units as long as emission standards are met, which had developmental based on the techno-economic feasibility, including effect of the pollutants and the health and other environment. It was also placed on record that the Central Pollution Control Board is regularly monitoring its emission from the CPC producing units. Further, in the impugned annexure number so-and-so dated so-and-so is as against the specific signal of the industries producing goods at petroleum, oil, or gas refineries. Altogether, a different stipulation had been made in reference to the raw materials or the byproducts of the raw material of the oil refineries. From whatever angle the matter is looked into, including the stand of the respondents in these counter affidavits, no tangible and or cogent reason is discernible toward denial of the benefit that produced to the petitioners under the NIP 2007. In such a situation, the respondents will have to reconsider the decision contained in the impugned letter dated so-and-so, annexure so-and-so, consistently with the observations made above, and then pass an appropriate order. Let the required exercise be done so-and-so, so-and-so.
Yes.
So this honorable court, my lord,
Hmm.
two issues the honorable court held. That so far as the refineries, it is only produced by the refineries, which he puts in the negative list. And second, pollution ground which he have taken, that is also cannot be stand because they have also the Pollution Control Board also filed the affidavit in the PIL stating that there is no pollution effect. After that, they have passed a fresh order at page 102.
Yes.
Crossing C para 2. The Government of India is implementing NEP 2007 with a view to give boost to the industrialization of the northeastern region. How the scheme contained in the NEP is based on executive instructions which are not statutory and intended to cover legally enforceable obligations on the government. As stipulated in the policy itself, the government reserves the right to modify any part of the policy in public interest. As such, the benefit under the benefit scheme cannot and should not be claimed as a measure of legal right. Now, first of all, your lordship may kindly note it, that the NEP had never been amended. neither modified. And lordship is aware, my lord, that though they may amend the policy which has not been done in the case, but that will be also subject to the doctrine of the promissory estoppel.
That's correct.
Because in the Motilal Padampat also, my lord, it has been held that the change of policy cannot be allowed to take away the accrued and vested rights of the petitioners. Now, the next one, my lord. The objective of the policy is to promote industrialization through certain tax concessions and other monetary incentives in the industry-based NER states to create jobs for the local population. The government has consciously kept certain type of industry out of the purview of the policy in multiple considerations such as exclusion of the production of certain high revenue yielding goods and goods which production is detrimental to the environment and public health. The negative list is the listing of the goods and not of the manufacturers. Negative list specifies industrial production of specified goods that will not be incentivized under the scheme. The policy does not intend to distinguish between different manufacturers of the same product. Hence, all products producers of the CPC bitumen emissions are entitled to the benefits. Now, you also can read the policy once again. Nowhere, whichever he is saying by office memorandum, it is stated in the policy, nowhere. Now we say that we see about the goods and thereby all producers will be entitled to the benefits. Now we'll also further see. But he also mentioned the scheme run through executive instructions has also to factor budgetary considerations. Fresh registration NEIPP and so of this department with as the liability under the had been incurred far in excess of the plan allocations. However, it is clarified that the scheme under 2007 has never been cancelled or withdrawn. The intention of the government is to broad-base the spread of limited resources effectively to support large number of industrial units and greater employment generations. The department had carried out a evaluation study on the impact of the transport subsidy scheme in each target stands through and in the independent agency. And so the study has observed that although disbursement of the subsidy spanned across all industrial units, the coke manufacturing units has operated, commenced, had cornered bulk share of the limited and in some cases negligible contribution in terms of the environment, pollution and so. In view of the so, they will not fall.
Okay.
Now the question is that the issues which have been raised.
Understand, your case is that the fundamental issue was you are in a negative list. This court has said that reading of the policy does not say so. And therefore, and they also took a stand that this is environment and all. The court says environment is not a ground in view of pollution. Now the matter was remanded back for fresh consideration in terms of the observation made by this court.
My lord.
Now they have passed an order. According to you, these cannot be ground and they cannot sit over the determination already made by the High Court. And these cannot be the ground because all these reports are subsequent. It is relatable to the period where you are.
Grounds which they are saying that the coke industry is taking away the major portion. Now, that the policy has not said that, this industry will not be taking away the small amount or big amount. Neither, my lord, they say in the public interest. The policy has not been amended. The policy remained as it is.
So meaning thereby, did they furnish given benefit to coke industries also, other coke industries?
Yes.
But they are saying that study of the
They
already.
say that the coke industry is below, this the coke is different. One is from coal.
Okay.
Coke is prepared.
Ah.
So the coke, other industry have taken, they say the coke industry have taken major benefits.
Okay.
So if that was so, if you are not interested in giving it, you could have specified coke industry will not be entitled to. But you have never said,
Okay,
any of the grounds, my lord, which has been mentioned here, had no relation with the interpretation of the negative list in the industrial policy. Policy has to be interpreted on the basis of what it contains. And it has been specifically said that the only so-and-so product produced by the refineries and so-and-so will be not be. That was the view given by the Revenue Department of the Government of India also. That no, these industries will be entitled. Now, they are saying one pollution, one the fund, because maximum fund has been taken away. Second, they are saying that industrial policy, the policy that it runs through the executive instructions, and thereby the intention of the government is to broad base and spread the limited resources effectively to support a large number of industry units and greater. So who stops? This was the intention. If this is the intention, they could have amended the policy. Division mature. ये आते हैं division mature. Now, this issue, in fact, earlier also came out before this one court by a division bench, my lord, the matter was considered. Division bench judgment, DM Barua से भाई, आते हैं DM Barua judgment. India carbon. Now, you'll also be aware, Milord, that Supreme Court has held, Milord, that the industrial policy, because certain notifications are to be issued to give effect to the industrial policy. And the Apex Court held that the industrial policy resolutions are binding and the executive instructions or notifications cannot override the industrial policy. India carbon judgment division venture. Para 8, you'll also see. Para 7. बाकी कोनो फाइल को मैसेज नहीं है. May I read, my lord?
yes.
Coming to the second question, namely the issuance of the notification by the state government in exercise the power under Section 7 of the Bihar Finance Act, it is true that issuance of such notification entitles the industry unit to avail the incentives and benefits declared by the state government is non-industrial policy. But in exercise of such power, it would not be permissible for the state government to deny any benefit which is otherwise available to industry unit under the incentive policy itself. The industrial incentive policy is issued by the state government after such policy is approved by the cabinet itself. The issuance of notification under Section 7 of the Bihar Finance Act is by the state government in the finance department, which notification issued to carry out the objective policy decisions taken in the industrial policy itself. In this view of the matter, any notification issued by the government under in exercise of the power of Section 7 of the Bihar Finance Act is found to be repugnant to the industrial policy declared in the government resolution, then the said notification must be held to be bad to that extent.
So you want to say by this authority,
My lord.
a statutory kind of status has been given to a policy decision, industrial policy decision, when it is approved by the highest authority, that is the cabinet. And even if in exercise of power under some act,
My lord,
in derogation of that policy or benefit given, shall not be sustainable.
my lord,
This is
my lord.
proposed.
इंडिया का अपना जजमेंट नहीं ऑप्शन इंडिया का बनव वैसे डीएम बरोबर डिवीजन बेंच जजमेंट असे now a issue came up with this honorable court also, wherein the central interest subsidy scheme was there, and a clarification was issued by the authorities of the central government, which was contrary to the industrial policy scheme itself. Now, this honorable court committed directly to your lordship,
Paragraph
paragraph 47.
47. Page
Page, my lord, 32.
yes.
It is the opinion of the court that the interdepartmental communication dated so and so, as well as the operational guidelines, cannot limit the petitioner entitlement in terms of subclause so and so, or clause so and so of the notification dated 27/7/2007. That is what the scheme, my lord. Be that it may, this court does not have the expertise to decide as to whether the various components which the petitioner alleges that the same ought to have been included in the entitlement, as they are part of the various industrial plant and machinery erected by the state. The court direct the respondent authority, more particularly the respondent was so and so, to make assessment of the petitioner entitlement purely on the basis of clause 6 of the notification dated 27/7/2007, and without being influenced by the communication dated so and so and operational guidelines. Now, if I take it also, my lord, to the observations at page para 41. Reported actually. The industrial policy 2007 was issued by,
Just a minute.
my lord.
Page 28, isn't it?
Page 28, my lord.
Yes.
The
Yes, read it.
industrial policy 2007 was issued by the government of India after such a policy was approved by the cabinet itself. On the basis thereof, a notification was issued on so and so, which stipulated the benefits of central investment subsidy. Clause 6 specifically dealt with the plant and machinery for manufacturing sector. Clause 6A dealt with the plant and machinery and components pertaining to the service sector, biotechnology industry and power generating units. In order to bring the components of plant and machinery in respect to service sector, biotechnology industry and power generating industries, a separate notification was issued by the Ministry of Commerce and Industry dated so and so, and thereby making this notification dated so and so as an addenda to the notification dated so and so. The question arises as to whether by way of interdepartmental communication dated so and so and the operation guidelines, there can be any modification of the clause 6 of the notification dated so and so. That was the policy bill. In the opinion of this court, the same cannot be overridden by an interdepartmental communication or operation guidelines, inasmuch a notification dated so and so has been issued in accordance with Article 77(1) and 2 of the Constitution of India. In order to modify or amend inter alia said notification, there is a requirement of issue a notification, and stated in interdepartmental communication or operation guidelines cannot limit, more so when the notification is silent to that effect. So the court came to conclusion below. Thereafter, Lordship also see page 42. 50. And there are 42 below.
42, yes.
At this states it is relevant to take note of the judgments of Supreme Court to be the learned counsel appearing on behalf of the respondents are relied upon. That is in the case of prevent fraud and manifest injustice. There was a modification made in the notification. This modification was made by way of subsequent notification and not by way of inter-department circular or by the operational guidelines. Under such circumstances, the said judgment of the Supreme Court cannot be made applicable in the instant case. The court finds it relevant to refer to the judgment of the coordinate bench of this court in the case of PDP Steel so and so. The said case was also in respect of the industrial policy. However, the scheme was with respect of the capital subsidy. The issue involved was that the notification issued for the benefit of the capital subsidy scheme stipulated that the eligible industrial unit established new existing industry located anywhere in the northeastern region would be given interest subsidy to the extent of 3% of the working capital advance of the scheduled bank and central bank so and so for a maximum period of 10 years from the date of commencement of the commercial production. The benefit was sought to be curtailed by issuance of a circular which stipulated that the quantum of interest subsidy admissible in the case of existing units which has undergone substantial expansion of the so and so would be 3% of the increase in the working capital loan actually drawn after undergoing substantial expansion over and above the average of the working capital loan availed by the industry into financial year just preceding the date of commercial production after undergoing substantial expansion. This communication was put to challenge before the court on various grounds, including the ground of jurisdiction. The coordinate branch had interfered with the said data dated so and so on the ground that the same is contrary to the policy approved by the cabinet and so and so. That judgment of PDP Steel, in fact, I should have placed first.
Yes, yes.
And an SLP was filed against the judgment in the PDP Steel. That was also dismissed.
That in PDP Steel, that.
Below, the number of petitions were disposed of by the said judgment. And one of the petitions below, they went to the Supreme Court and the same were dismissed. You'll also find the 1230 in the PDP judgment below.
PDP is a paragraph.
No, I will taking the first page itself. WPC number 57 of 2018, 1230 of 2016.
WPC 57 2003 1230 2016.
The SLP was filed against 1230 of 2016.
Okay.
That was dismissed. The relevant part of the PDP Steel, Millard, I have already read before.
Yes, yes. Para 23.
Now, in fact, where they misplaced the judgment, there was a judgment of the division bench of this Honorable Court, Millard. All judgment, wherein also the issue came up, they produced by the findings and the same thing.
Okay.
And this Honorable Court held that the petitioner, since it was not a refinery, will be entitled to the benefit of the transport subsidy.
Okay.
In fact, I took the copy, but somehow.
Any citation or can you give it?
If, my lord, you lost it.
Yes, yes.
Tomorrow itself, I will mark it relevant portion.
See, how much time they will take, I do not know. But I will not keep it as a CAV, will fix a date and dictate this order.
You know, my submissions, and in fact, this summary of my arguments in the affidavit reply. You'll also read the affidavit reply.
In reply, na? Two. Yes.
Whereas page 17, my lord, internal page 17. I've summarized all my submissions.
Okay. Yes.
So, my lord, my humble submission is that the clarification which has been issued is absolutely contrary to the industrial policy as well as the same seeks to override the industrial policy regulation, which is not permissible, and thereby the grounds which have been given in the impugned order, in spite of there being a judgment of this honorable court or direction to consider it on the basis of observations made in the said judgment, they have again reiterated whatever they have to say the same thing, and thereby the same is not tenable in law, liability is set aside. I'm not burdening your lordship to the promissory estoppel judgments because the promissory estoppel judgment, if your lordship want, I will mark it.
No,
and
not
give it to you,
necessary.
lordship. It is number of judgments from Motilal Padanpad, but I think that will be, may not be required.
Not,
also.
it not very clear. Now, you have argued on this is WPC 6416.
The all other cases also the same circular each under challenge.
Same, and all are having those license and all
Yes,
those,
yes, everything.
those have.
Yes, yes.
Okay, only the date of the impugned order will be different.
Impugned order is also same, my lord, because that's the circular.
No, that is a circular, but subsequently that
Subsequently, no order has been passed.
that representation that in 6417
Do
also
one thing, my lord.
you have approached the High Court earlier.
Yes,
There is a-
6416 I approached. And in two other cases also I approached. I will do one thing, my lord, in different cases, just a summary.
Just that is what I want.
I summary.
Because if necessary, we'll pass a common judgment
But-
instead of going
It will
to.
be a common judgment, but facts I will just,
Facts will dictate in three separate parts.
my lord, I will prepare it. Small, one paragraph, one page, and I will prepare it. I think let them make a reply if necessary, I will give a reply. I'm on associate organized with me.
Lordship, already the previous judgment that was discussed, Lordship, the facts, etc., and it was remanded back to once again go through the judgment, Lordship, and then Lordship, in paragraph 8, we have stated that it is in the negative list. That is why it will not be, exemption would not be available to them, Lordship. Thereafter, Lordship, that matter after the judgment of this Honorable High Court, Lordship, may kindly come to page 125, the running page, paragraph 12.
120.
125, possibly page 4 of my affidavit, that will be 125.
Okay, 125.
125. So
Okay.
paragraph 12, Lordship. I'm just saying that after the judgment, Lordship, the government intends to submit in this regard that in pursuance of the above court order that
No, paragraph 12.
yes,
That with regards to statement made in.
yes,
paragraph
Lordship.
26.
So and so. So from this last two line, Lordship, that was re-examined at the highest level of the Department of Industrial Policy and Promotion, taking into account the comments on the issue received from other stakeholder ministries or department and the internal financial wing of the department. Upon re-examination, the department concluded as under: a government order should not be dissected and interpreted word by word, clause by clause, and not subjected to out of context, out of intent interpretation. The government order to do not go through reissue vetting by legal advisors like a bill to be passed and act by legislature. It is possible that the drafting of a government order is insufficient to fully capture and articulate its intent and purpose. It should be read for what is plainly written and intended therein. Hair splitting government order to claim or deny any benefit. So
That only.
that Lordship. Then Lordship, intensive scheme like this, any IIPP is not an act of parliament. It is not intended to confer legally enforceable right. As stipulated in the order itself, the government reserves the right to modify any part of the
So these are your
policy
grounds.
public interest.
These are
So
your
we
grounds.
have gone after the judgment, Lordship, we have discussed this matter with other department also, like Department of Revenue, Department of Environment and Science. And this is broadly what is the decision before passing the order, impugned order.
Do you dispute that the industry's policy was creation and a policy of the cabinet, union cabinet?
So as per this Lordship, that we say that this is an act, is not an act of parliament.
No,
This
it's
is
not an act of
act of
parliament. I
parliament.
understand. So do
Yes.
you propose to say, see if it is not an act of parliament, then on the basis of inter-ministerial or inter-department clarifications, you can interpret it.
Lordship.
But you are yourself is saying that it is not necessary to dissect and hair splitting. Anyway.
This is before passing the order that the six decisions were taken. This is broadly stated by the authorities lordship. And already mainly purpose is that it is not environment friendly. So many hazardous situation are there. Because of that, we have distinguished which one will
Anything
be.
in the policy as regard environment?
Lordship, this
207.
policy here, in fact, Lordship, this negative list list items should not be registered. That is one condition.
Anything in the policy that why these institutions are things are placed for in the negative list?
The whole policy is. The negative list is there, Lordship, which will not, which will fall in the negative list that is there. On the monitoring mechanism, there those are there, and in page 135 clause 7 is there, Lordship.
Page
That
130.
135. Clause 7. It may be ensured that no industrial unit should be registered for benefit under so and so if it is covered under negative list provided in para 10 and 13 of the policy and annexure 1 of the respective subsidy scheme. But it was registration is by the district industries and commerce lodge. So as per this, such an industry should not be registered.
Which paragraph? Coverage duration?
Lordship, this page 135 clause 7.
Page 135.
5.
Okay. Just a minute.
Clause 7.
Just a minute. 135. Okay.
Yes. It may be ensured that no industrial unit should be registered for benefit under so and so if it is covered under negative list provided in para 10 and 13 of the policy and annexure 1 of the respective subsidy scheme.
Clause 7.
Clause 10 that is mentioned, negative list, and 13.
No. In this paragraph, page 130.
Yes, clause 7.
Clause 7. Where is para 10 and
Para 10 is page 131. Page 131
para 10
is
is
negative list.
131. And where is
131.
para 30?
13 is value addition.
This is not necessary in our case.
Logic.
131.
131.
Negative list.
Negative list. That is in the policy that those which are not which are in under the negative list should not be in fact registered. But if it is registered, then also they cannot claim that exemption, lordship. And
Where will you get this first schedule
next,
of chapter 27? Anywhere in this record? Dr. Saraf?
I'm not bought it, but
Huh?
they no dispute that is.
No dispute. Just I want to see
I've given my lord.
that just that part of
I'll
it.
take a print out of it.
Schedule to the central exercise.
I'll-
That
I'll-
part producing.
For the division bench judgment, I bought it now. I'm taking the help of the
Yes.
print out of the High Court.
No, it's. Yes, and
lordship, this the impugn order.
so
is-
your basic stand is that the impugn order itself reflects the reason. And everything is non-material that it has been clarified by different departments. So our decision is in conformity with the policy, and this policy do not create any enforceable right. Therefore, read court should not exercise jurisdiction.
If necessary, in near future also, if it is hazardous to public, we can modify it also. That is also one.
But there is no modification to the policy.
That at that time.
There is
Possibly
no,
not,
no, at that point of time, the policy was not modified, but it is an admitted position that there was a confusion in the mind, and therefore a clarification
Yes.
was sought. But clarification was sought from the department, specific department, revenue and all. And on the basis of this, some executive has taken a call that this is this. But there is no as such amendment or the modification of the policy by the policy makers. Okay. Yes. Anything to be added?
Oh,
Judgments? Nothing.
Division bench judgment of the loss of penalty. Twenty-two para,
Para 22.
my lord. May I read, my lord?
Yes.
I will teach from para 20 itself, my lord, para 20.
20.
20.
Okay.
Mr. Goswami so on the other hand contends that it is true that the scheme is not applicable to plantations, refineries and power generating units. According to so-and-so, the responding company is not a refinery unit. It manufactures CPC which can be produced in an industry unit which is not a refinery. Besides, CPC is also not exclusively a refinery product. In this regard, so-and-so has drawn our attention to the affidavit of opposition filed by the Union of India in matter number so-and-so before the Calcutta High Court, particularly paragraphs 10, 15, 16, 20. From those, there a paragraph, it is absolutely clear that the responding company is not a refinery and therefore is entitled to the transport subsidy. On the rival contention of the learned council of the party, it is to be seen whether the responding company is entitled to transport subsidy. On perusal of the transport subsidy scheme, we find that the transport subsidy is available to all industry units in the specified areas except plantation, refinery and power generating unit. So-and-so does not dispute that the responding company is not industry unit. He also agrees that the responding company is not a refinery. In the scheme of the expression, refinery has not been denied. If you go by the dictionary establishment, the plant where oil, sugar, metals, nutrients are refined. In the affidavit of opposition filed by the Union of India in so-and-so before the Calcutta High Court, it has been stated that in order to know whether CPC is a refinery product or not, the Ministry of Industry, Department of Industrial Promotion called a meeting on 26th October 1988 about the eligibility of the CPC unit to transport subsidy. This meeting was attended by the representative from the Ministry of Petroleum and Natural Gas, Assam Government, Indian Corporation, Bombay, and Director General of Technical Development, New Delhi. The representative from the Indian Oil Corporation clarified that while processing the crude oil, different end products like gas, petrol, kerosene oil, etc. obtained out of the raw materials, coke, CPC is manufactured. As far as refinery is concerned, RPC is the end product and it involves an entirely different processing operation to produce CPC from RPC. Besides, in paragraph 15 of the affidavit of opposition, it was mentioned thus: the issue is whether CPC produced by India Carbon Limited is a refinery product. Obviously, it is not a refinery product in that India Carbon is not engaged in refining or petroleum crude like other private consigning units. Again, in paragraph 20 of the said affidavit, it has mentioned that India Carbon Limited Guwahati is not a refinery. This affidavit was shown by Undersecretary to the Government of India. The respondent company was specifically mentioned about this affidavit in para so-and-so of the writ petition and also para 10 of the reply. The respondent in the above civil rule are silent without saying anything about the contents of the affidavit. Therefore, the contents of the affidavit are deemed to be accepted by the respondent. The respondent, having admitted about filing of the affidavit, have not given any reason why there was departure of the stand taken. No material has been produced before this court. In view of the above, we have no hesitation come to conclusion that the respondent company is not refinery. As it is not refinery, the prohibition regarding the applicability of the scheme does not come. As per the scheme of 1971, the transport scheme was given to all industry units, barring plantation, refineries, and power generating units in the notified area. Having announced such a scheme, the government is bound to honor its assurance. In the present case, also, the responding company did pay some money. This itself is sufficient to indicate that the responding company is not refinery, and as such, the responding company is entitled to get the transport subsidy as per the scheme. However, so-and-so submits the Government of India has full discretion to reject any claim. In our opinion, this clause has no application in the present case. We have gone through the judgment passed by the single judge in so-and-so. In the said judgment, the single judge had mentioned that the government had discretion to accept or reject any claim. The single judge in the input judgment had also accepted the same. We do not disagree with their proposition. The government may refuse to grant subsidy in appropriate case. when it appears that a particular claimant does not come under the purview of the scheme, but this does not mean that the government has unfettered discretion to reject claim whatsoever they like. In view of the above, we do not find any infirmity in the input judgment, pass balance angle, so and so is rejected. So here, my lord, it was clearly held that this is not a refined product. Now, they are again saying that this is a byproduct. So where the scheme says, and they are saying that it should be read, objects should be gathered from the policy. I am also saying from the policy itself, where it says that environment, you'll also find pan masala and tobacco also is banned, negative list. What environmental effect is there? If environmental only effect
The
is there.
policy is not saying that it is only for environment.
That's why I'm saying, Milord, that negative list also contains the pan masala and below the tobacco. So there this pollution effect is there. And you have given me the consent to operate. The Pollution Control Board is always monitoring. Otherwise, industry could have been closed down. No industry can operate without the consent to operate and without the.
So that's all for today.
I look.
Maybe fix a date before vacation. Last part will dictate in the open court. We'll try to give it before vacation, otherwise because too many matters are.
Thursday, 26th, Milord.
So you you have given everything? Just
I only the
the
source.
facts, because your arguments are also, I have seen additional. Just their arguments are also those page.
The same order they are reading.
That affidavit in A, B, C, D. That is your argument. What I want is the different facts of each of the cases. Any difference.
Well, 3-4 days, within 2-3 days, I'll give it.
You give it 2-3 days, but we are fixing it not this week, thereafter.
No, 26 will be the. I think next week.
26 will be 20, I will be out of 26, no? Friday, Thursday. Friday, Saturday, Friday, I'll leave.
Thursday, Milord, 26.
That is be on Tuesday.
Tuesday, Milord.
But you give that in
Yes.
previously, so that on Tuesday we can dictate this order. If
24.
anything required, I'll go through. If anything required, I'll seek and clarification, otherwise I'll dictate in the open court.
24, Milord.
24, possible? Okay. Too many matters are fixed because of the vacation.
We
rush.
heard it before this vacation. Before vacation, we can
Before
also.
vacation, there will be a rush. And one bench is shortage of bench. Brothers Manish is not sitting, so brother Michael is in bench for sure. Hopefully next week position will be changed anyway. Hard in part, list for further hearing on 24. And what is your stand? Nothing, they are registered with us. We have sent it. That's all. We have no role.
And
But
in
we have
fact-
registered them
In fact,
under that industrial policy.
excise duty exemption they are granting. Under the same policy.
Over for today.
So there is one more matter, similar matter.
Hmm.
I will mention tomorrow, so that matter also can be listed on that day.
If facts are same, if we
Same
need
facts,
not.
I will prepare similar.
Yes.
Same facts.
Yes.